Welcome back. This is part 2 of unintentional torts. There are 2 of them, negligence and strict liability. You see the elements of proof listed below. Please read your text, and I think they've got a pretty good explanation as to each one of these elements of proof. Notice in particular that proximate cause means that it's foreseeable that the particular breach of duty could result in specific injuries. Now, unintentional torts, negligence, the big one. Where do these duties come from? Well, they come from professional code of responsibility. That's usually licensed professionals like doctors and others in the medical profession, lawyers as well, accountants. It could come from statutory law, such as a speed limit, breaking that as you're driving, or common law, just public policy that has been developed over the years, and that this duty ends up causing damages. Breach of that duty, and here again a reasonable person standard is used for ordinary people, but for professionals like lawyers, doctors, and anyone really licensed, we use what's called the community standards. That is, how would other people in a situation with the same kind of education, what standard would be commonly found in that local community? Finally, causation is a but-for standard. But for the incident, the person wouldn't have been injured. And the other issue is proximate cause. Would a breach like speeding, is it likely that that is foreseeable that it could lead to injury? And finally, one has to offer evidence on damages. Defenses to negligence, you did a case study, student brief on the assumption of risk. That involved the question of law as to whether when a person tells a contractor, no, I don't want you to repair this known danger, and sends them home, have they not assumed the risk, and therefore, under law, as a matter of law, they lose their right to get damages from the defendant. Superseding cause means that an accident has occurred, and then another injury is sustained from some other event unrelated to the defendant. And that will not alleviate the initial damages, but it will knock out recovering from the party that started this chain reaction. I'll give you an example. You're walking down the street and you push the person into the street. They get up, so they maybe twisted their ankle or something, so you're liable for that. The person then goes in a department store, and because of peach being on the floor, they trip on the peach and they injure their other foot. Well, you would not be able to recover from the first person who pushed him into the street for the damage to the other leg. That would be a separate suit. It's a superseding cause of an injury and not a consequence of the first push. Contributory negligence is saying, hey, look, you contributed to your injuries, and that's a defense to negligence. Now, the video we saw, The Trouble with Lawyers, explained that each side pays their own legal fees, whereas in other countries, when someone is sued, if they win their case, they can collect attorney's fees for their own defense. Whereas in the U.S., we don't, and so that's why that female attorney we saw in the video who was suing all her neighbors, that's why she could get people to settle. She said it's cheaper to pay me than it is to pay for your own legal defense. The other element here is that there's no punitive damages unless the action was intentional or a case of gross negligence. For example, some pilots were involved in an airline accident, and it turned out that they didn't bother to do the safety checklist prior to takeoff. That's pretty gross negligence, reckless disregard for the safety of their passengers. So that airline did face punitive damages. We've already talked about malpractice where the community standard is applied. In South Carolina, we do not have this. So this is not a South Carolina law, but I want you to be aware in Texas and some of the other states, they have what's called a comparative negligence statute. If you're responsible for more than 50% of the accident, according to the jury, then you don't get any payments from the defendant. On the other hand, California has what's called a pure comparative negligence. Say you're deemed to be 90% responsible, you would still get 10% of your damages awarded to you by the jury. Funding of litigation. This came out in the video. Plaintiffs sell their legal right in exchange for legal representation, but they don't get a whole lot because when you add the out-of-pocket expenses, the court fees, travel, and investigators, depositions, and other things that are related to the case, the plaintiff is really not made whole. And that's an important true-false question. In our legal system, even though you hear about these multi-million-dollar settlements, when all is said and done, very, very rarely is the injured party made whole. Now, the other thing is, sometimes you have a situation where, again, the plaintiff has sold their legal right to an attorney. This can be problematic for both the attorney and the client. Attorneys want to negotiate, send a letter, settle it quick, get in some kind of money. And the plaintiffs sometimes need cash, so they agree, but others can get very greedy and insist on a lengthy trial. And attorneys don't want to do that because they're then spending a lot of money on these out-of-pocket expenses without getting any compensation until the matter is actually settled. Class actions, they are allowed under both state and federal rules of civil procedure. The key to class actions is the certification. Companies will spend a lot of money to battle over whether or not there's a similar class that can be consolidated into one lawsuit. And again, you saw the video in which there was a lot of controversy over the fact that the lawyers get huge, huge fees and the victims get a little coupon or something. We've already discussed the defenses to negligence in Texas, so they have the comparative negligence statute, and we've already discussed the issue of strict liability. I do want to mention something called tort reform. I don't know the South Carolina reality, but in Texas, they put a top limit on the so-called non-economic type of damages, pain and suffering, loss of consortium. These are very hard to measure, and they're subject to juries getting very emotional about, the pain and so on. Texas limits all those damages to $250,000. They did some other things on restricting these so-called quack expert witnesses. They have pre-trial depositions so that the judge can say, no, this guy's a nutcase. He's not really qualified to give an opinion as to the damages and the medical situation. And they changed the definition of volunteer and good Samaritan to broaden it a bit so that physicians who stop and render aid to somebody can't get sued because they weren't able to save the person completely. Actually, it was amazing. This worked. Medical malpractice dropped by 30%. And in one county, they were down to one OBGYN who was delivering babies. And county is not a small one. It's the city of Corpus Christi and surrounding area. So many people were suing over the birth of their children from things like multiple sclerosis and cystic fibrosis and causes that not necessarily related to patient care, and that they were getting, 6 and 7 figures settlements and so on, and the OBGYNs just simply left the area. And there was one doctor for an entire city of Corpus Christi. And so that was a crisis. And since then, the OBGYNs have come back to Corpus Christi. And so I ask you, is that a lesson for the United States as a whole? Don't know, but there it is. You decide. Business perspective, some quick advice. Number one, buy insurance. They call it risk management. But there's all kinds of premises liability insurance that one can buy, product liability insurance. Very important to do that. If you're going to be in business, you have a moral obligation to have the financial resources in case someone is injured from your activities. Second thing is to use in-house counsel or even an outside counsel who normally represents the type of industries that you're in, and get them to do an audit of all of your activities and where your liability may be. And that in combination with an insurance agent so that you can have the right kind of insurance. And the other thing is to make sure that you join a trade association, because they publish a lot of stuff on formal safety and product quality teams and how they can, when used properly, reduce your number of lawsuits. One of the things that you learn the hard way is to settle quickly and settle silently. You don't want bad PR from a bunch of lawsuits. Second thing that, unfortunately, these two I don't like, but it is part of the reality. What some companies will do is just force the plaintiff to spend a lot of money, and it becomes the battle of who has the most money. The other thing is to drag it on so long that the complaining party is deceased from the issue, or witnesses have moved away and whatnot. I don't like that, but that's what you might face in trying to combat a very large company with lots of deep pockets. A moment on the exam and the quiz related to torts, that is, to this chapter. I'll give a few on the quiz, maybe 3 or 5 questions where I give you a story and you're going to have to recognize, is this invasion of privacy, is this negligence, what is it? Then the other thing I recommend is, please, when you review the types of torts, the names, look at the stories that are told in the book so that you have examples, because I will use similar ones to test you so that you have a handle on the vocabulary. Finally, please read the textbook. I see a few people are trying to do quizzes and they're not reading beforehand, and that's why they get stumped and timed out, because they're looking for correct answers and they're just not familiar as to the layout of the textbook. So go through the book first, any notes from class, and these PowerPoints, the 2 of them on Chapter 5, before you do the quiz on 5. Thanks a lot. Good luck.